Hey, Adam Brown here, A Brown ESQ LLC. I'm talking about unpublished appellate decisions that came down. We're not talking about these to say they're binding. We're not talking about these to say they're precedential, that you can cite them in court. I'm talking about them as a scholar of the game. I love reading these decisions. It's a practice I have had throughout pretty much after my clerkship. I just read these things and I learn a lot and I love them. So, I'm going to talk to you about another unpublished decision that just came down recently, November 1st, 2023, MLH versus WKP. These are my thoughts about this decision. Some very good attorneys on this. Very interesting case. This case involved an appeal of a restraining order. We see a lot of appeals of restraining orders in New Jersey. In general, you have to understand that in New Jersey, a restraining order lasts forever. And I put quotation marks because there are some ways that you can get a restraining order off of you. Now, this case kind of talks about that. But a restraining order in the state of New Jersey, once it's entered against you, that's it. I mean, you're on the domestic violence registry. I don't think you can't adopt children. You can't have a gun. You can't be around someone. You can get your compensatory damages, like I talked about in the other video. You can get attorney's fees. You can get items property. In fact, if you're renting an apartment and you get a restraining order, you can break the lease. I mean, without penalties. So it's a very big deal in the state of New Jersey if you win a restraining order. And it's a big deal if you lose one and have one against you. So anyway, going back to this case. Again, non-binding, unpublished, not precedential. Interesting facts. This person, the defendant in this case, had a YouTube channel. Probably still does. I don't know his name. And on the YouTube channel, he pretty much bashes the other person that got the restraining order against him. There's some choice words here where I'm not going to repeat them. They describe the person as manipulating, conniving, other things that are, bad language. The person says, "I have a surprise for you." They did that in that YouTube channel. So the bottom line is, the person who heard these, and the person had a lot of subscribers, like hundreds of thousands of subscribers. The bottom line is, the person who they were saying this against said that's harassment. I think they were formerly married. It talks about, the YouTube channel is kind of centered around the divorce. It's like their businesses out there. So anyway, bottom line is, he lost a restraining order. And, after the restraining order case, he gets a lawyer to try to dismiss it. The lawyer, I guess, in this case, they didn't do a formal, what we call Carfagno application. A Carfagno application is what I was kind of describing earlier, how you can get a restraining order off of you. There are specific factors that are analyzed that take into account whether or not the restraining order should be off of you. Now, you normally don't see it like just a week or two or a few weeks after the restraining order. You see it like years later. The person has substantially changed. There haven't been incidents of violence. The victim is okay with it. Sometimes the victim's trying to talk to the person. I mean, they look through several factors in a Carfagno application. And the case, as a matter of fact, I could just pull it up for you now. Anyway, in this case, he didn't do that, but he basically said that the person had nothing to worry about. This was just YouTube. This is freedom of speech. This is this and that. I wasn't directly threatening the person, but they did find that the sole purpose was to harass the person, to be in contact with the person. Do I agree with the trial court decision? I'm not going to say. I believe in freedom of speech. That being said, he lost. I mean, he kind of blew the deadline. He didn't file a notice of appeal within 45 days, which you have to do after the restraining order hearing. He didn't go through the Carfagno application the correct way, with itemizing the factors, and the appellate division affirmed the decision in that one. So, I don't know what happened next after this, if he was ordered to take down the YouTube channel or what have you. But just note, I've seen these cases, and the reason I love reading all criminal family, I've seen cases come down recently where someone even on a LinkedIn chat, looked at someone's profile while they had a restraining order against them, and that was contact when it said so and so viewed your profile. So online, social media, YouTube, that stuff is a big deal. It's not like de minimis contact. People are making cases now. We can't rely on this to make yours, but hypothetically, there are a lot of precautions that you need to have if you're going to bash someone nowadays and online. That could hurt someone and make them feel annoyed, alarmed, harassed, and you can get a restraining order against you if you have the right relationship. Hypothetically, now you can't rely on this. But I'm telling you, it's a very different state that we live in now. Technology does play a major role in decisions. All right.